So you can also share your screen, sir. You can share your screen. Sir, we can see your screen. Can you play it as slideshow so that it will be larger? It will be larger.
Yes, this is my profile that the host requested that I put it up.
Good afternoon, everyone. I welcome everybody to today's webinar. This is series 2 of the webinar. As we have said, it is a legal awareness campaign. Can you all hear me, please?
Yes, you can go ahead.
Yes.
So it is a legal awareness campaign where we'll be addressing about 4 topics. But today is the flag off of this legal awareness campaign. So we have our competent barrister in the house. This barrister is our legal advisor, is the foundation's legal advisor. We have been operating together for a very long time. So I will introduce him, then later leave the floor for him so as to do justice to the topic given to him. So a person of Chimese Jacobs Pascal Ogugbara is the principal partner in the chamber here in Abeokuta, who is an expertise in litigation and arbitration attorney. He specializes in energy and environmental law, tax law, secured credit, transaction consultancy. Mr. CJP Ogugbara had his first LLM from University of Lagos, Lagos State, his second LLM from University of Ibadan, Oyo State, his LLB from Imo State University, Owerri, Imo State, and BL from the Nigerian Law School, Lagos, all in Nigeria. Mr. CJP Ogugbara is a chartered arbitrator, tax practitioner with the Chartered Institute of Arbitration, UK, and Chartered Institute of Taxation of Nigeria. He's an expert in energy and environmental law, tax law, and secured credit transaction law. He has published several articles, among which are use of sale and security interest as collateralizing instrument for SMEs credit in Nigerian post-COVID-19 economic recovery. Self-certification as a tool under the Common Reporting Standard, CRS, in tax administration for aliens and non-residents. An examination of the legal status of consumer and customers in electricity contracts along the Nigerian electricity supply industry value chain, and awakening reasoning for internationalization. The COVID-19 pandemic as a game changer in environmental law. Mr. CJP Ogugbara is the founder of CJP Ogugbara & Co., Swiss generis advocate, located in Nigeria. He is a seasoned litigation and arbitration attorney and had handled highly contested civil litigation cases up to the highest court in Nigeria. Please help me welcome Barrister CJP Ogugbara.
You're welcome, sir. Nice having you here, sir.
So now I leave the floor to Barrister CJP Ogugbara to take us on today's topic. which is the student rights.
I want to use this opportunity to welcome everyone on board, all the participating members of the Accurate Creative Minds Foundation. I titled this as the series number 1 that will be covering students' rights. I understand that there are other subsequent series will be taken up in the course of the discussion. Basically all will go sequentially, one after the other. But today, we're starting with students' rights. We'll have a run down on the outline we have. We have 6 items on the outline. One on the list is introduction. Second is the scope. The areas we'll be covering in the course of the discussion. The third one is Child's Rights Act. The fourth one is the 1999 Constitution as amended. Then I gave this particular title on the 5th item, Applicable Principles and Case Studies. So in this particular heading, we will be examining practical issues, both those that have been handled in the courts, be it Court of Appeal, be it Supreme Court, even the High Courts of Ogun State, and the one that I personally have also participated in. So I will express them to be able to have a common ground on what students' rights is all about. Then the 6th item on the list is our conclusion. In the course of the discussion, the conclusion ended with a phrase like whether students' rights is a myth or a reality. So, but as we go on in this engagement, we'll be able to know whether that my conclusion is accurate or it is misplaced. So, the first we have is what I would call general introduction. So, the first on the list is general introduction. First, who is a student? Because you cannot be talking like MK Abiola would say, that you cannot shave my head in my absence. Before you talk about rights of a student, it is important for us to understand the concept of what it means to be a student. A better understanding of this will become clearer when we get to the scope. But summarily, we'll rely on the definition offered by Section 2 of the Olabisi Onabanjo University Law. Section 2, under the interpretation section, it defines a student as a person who has been registered as a student of the university during a current academic year for a first degree, diploma, certificate, or such other qualification of the university as may be approved by the Senate as qualifying a person for the status of a student. Now, if we limit our discussion on the provision of Section 2 of the Olabisi Onabanjo University Law, we'll have a restrictive definition of the terminology studentship, because a wider understanding of studentship extends even to secondary school. Because I remember it's only people in the nursery or primary school that are regarded as pupils. Every other stage of education higher above the primary school, anybody in participating in that educational program is better described as a student. So, Olabisi Onabanjo University Law is not the only encyclopedia or where we can find an understanding of what it means to be a student. Now, there are other statutes, because when you look at other laws, as research may permit you, when you look at other laws as research will permit you, you will also see that there are other understandings or descriptions of what it means to be a student. The definition we have taken is as it concerns Olabisi Onabanjo University. One, for a number of reasons. There are two major reasons why we choose to. There are two major reasons why we choose to use Olabisi Onabanjo University. Hello. There are two major reasons why we opted for Olabisi Onabanjo University. One, because our focus is Ogun State, being that most of the participants are drawn within Ogun State, and most of the participants are perhaps students of higher learning. So there are other statutes that can explain what studentship is all about. But Onabisi Olabanjo is just a guide. So we'll go into rights of a student. Rights could be literary or legal. When we look at Black's Law Dictionary, it describes rights in two major headings. Black's Law Dictionary, 9th edition, Brian Gannon, editor-in-chief, at page 1436, defines right as follows. Number one, that which is proper under the law. Number two, meaning knowing right from wrong. That is different from what we're talking about. Number two, something that is due to a person by just claim, legal guarantee, or moral principle. Now, in that case, we are talking about rights as regards to what is due to a student by virtue of him or her being a student. For example, we hear about fundamental human rights as contained in the chapter 4 of the 1999 Constitution, ranging from section 33 up to section 42 of the 1999 Constitution. That covers the fundamental right of a Nigerian citizen. But in this concept, we're talking about the right of a student. So, literary meaning, that is what the number one represents. What is right? Defining right from wrong. For a student to move to the class, be seated, and be lectured, that is the right thing to do as a student. But a student to be accorded certain entitlements, benefits, and so many, whatever you have to accord to a student, being his right claim and entitlement, that is the student's right at that point in time. So we are talking about legal meaning of right. So that is what we will have as general introduction. Now, our scope, like I said earlier, we have no business talking about primary school pupils and nursery school pupils or kindergarten. Our concentration is on secondary school students and tertiary institutions. That's our scope. Now, let us get some important things. First, we cannot talk about a student without talking about a child. Because before becoming a student, one was actually, or is, a child. So who is a child? In the course of our discussion, we discover that any student less than 18 years of age is a child. And thus, as a student, the rights that would also apply to you, be it in the house of your parents and within the four corners of the institution of learning where you have found yourself, still applies to you. For example, we read from section 15 of the Child's Right, what it says as regards to right of a child to be educated. Section 15 says, every child has the right to free, compulsory, basic education to be provided by the government. Every parent or guardian shall ensure that his ward attends and completes his primary, junior and senior secondary school, or learns a trade. Any person who fails in his duty shall be liable on the first conviction to a reprimand and order for community service, and on the second conviction to a fine of 2,000 or 1 month's imprisonment or both. On any other subsequent conviction to a fine of 5,000 or 2 months imprisonment or both. A female child who becomes pregnant shall be given an opportunity to complete her education after delivery. It's deliberate to import section 15 because it gives us foundation of what we want to talk about. We'll also take it along with it, section 21, which says, no person under the age of 18 years is contracting a marriage, contracting a valid marriage, and accordingly, a marriage so contracted is null and void. There is a confusion if it is not properly taken care of. Now, there is no age barrier or delimitation or boundary as to who is a child by virtue of this section 21. And in that regard, we will bring in section 29, subsection 4 of the 1999 Constitution, for us to be able to understand it says, subsection 4 says, for the purposes of subsection 1 of this section, full age means the age of 18 years and above. Subsection B, any woman who is married shall be deemed to be of full age. I have to take it also along, taking into consideration what we have seen in section 15. I'm sorry. Let's go back to section 15 of the Child's Rights Act. Every child has the right to free, compulsory, basic education to be provided by the government. Number one, the government. Number two, it says every parent or guardian shall ensure that his ward attends and completes his primary, junior, and senior secondary school or learns a trade. Look at the punishment there. It says any person who fails in this duty shall be liable on the first conviction to a reprimand. Any person, that means inclusive of the government. Any person, because it is not proper, it will be very, very unjust to push it all to the parents or guardians that the duty is upon them to send their children or wards to school. But the law has made it clear that the government is to provide free, compulsory, basic education. and the government has, I'm putting a question now, provided it or not. Now, let's go to Section 18 of the 1999 Constitution. It says, subsection 3 says, government shall strive to eradicate illiteracy. And to this end, government shall, as and when practicable, provide A, free, compulsory, and universal primary education. B, free university education. C, free adult literacy program. The question is this: where do we go from here? How practicable are these provisions of the law? Let's look at Section 6, subsection 6, paragraph C of the 1999 Constitution. It says, the judicial powers vested in accordance with the foregoing provisions of this section, subsection C says, shall not, except as otherwise provided by this Constitution, extend to any issue or question as to whether any act or omission by any authority or person as to whether any law or any judicial decision is in conformity with the fundamental objectives and directive principles of state policy set out in Chapter 2 of this Constitution. When you look at Section 18, subsection 1 to 3, particularly paragraphs A to C, which has provided free, compulsory, and universal primary education, free university education, and free adult literacy program, as well as Section 15 of the Child Rights Act, we will understand that, because when you talk about right, if by any chance Dr. Accurate infringes on my right, Section 6 empowers me to approach a court of competent jurisdiction to ventilate my grievances. I can approach the court to enforce my right. But the right of Nigerian students to be offered free, compulsory education has been watered down by the provision of Section 6, subsection 6, paragraph C. Because Section 18 of the 1999 Constitution falls under the fundamental principle and directive, principle and directive policies of state policy. So it means that they are what we call not justiciable. So that means if the government fails to provide free, compulsory, and basic education, there is no enforcement in any court of law. A time came when this provision of the Constitution, under the 1979 Constitution then, was tested, when Lagos State government, put forward a certain law inhibiting the ownership of private schools. And then Archbishop Okoje approached the court. And the court, relying on section 6, subsection 6, paragraph C, clearly stated that the court cannot even put mouth in anything that has to do with education. You can see the wrong that has been done to the Nigerian student. So if the government decides not to make education an affair, even if the government fails to make it part of the annual budgetary, nobody can question that. And that is a very, very, very serious thing. Now, that having been said, let us move forward, because I have been able to establish by the explanations I've given, particularly as regards to Child's Rights Act, it is the right of a child to be educated. So when a child who has progressed to be a student, that right follows him or her, provided, I'm talking about as regards to Child's Rights Act, provided that child is within or below 18 years. It's technical. It's very technical in approach. But then, you cannot say because the child has crossed 18 years, therefore the government is not under any liability to provide any free education. Let us not forget that when this individual who has now crossed the boundary of childhood, when he was still within this bracket, this right was not provided. So, in Nigeria, as it is today, it becomes a serious issue because the government, upon whom lies the responsibility of prosecuting parents who have subjected their children to child labor, keeping them away from school, the government cannot possibly prosecute them because the government itself is culpable at this point in time. Because the law says any person who fails in this duty shall ensure, who fails in this duty shall be liable. I mean, of course, under the rule of law, the government, the individuals, the citizens are all subject before the law. That's what we call constitutionality. The government and the citizens are equal before the law. So if the government has failed in its duty, do you now have to take it to the doormat of the parents when the government has not been able to do what they are supposed to do? So it's dicey. So we'll move also to what I called applicable principles and case studies. Now, every student in any learning institution, I choose to use the word learning institution to cover both university, secondary, and any other applicable institution of learning. I give an example, Olabisi Onabanjo University, which will always be our case study. They have what they call handbook. Every student, upon being admitted into the school, gets through orientation. In the course of the orientation program, the student is given the opportunity of understanding what it means to be a student within that institution. You will also be given such important equipment like student's handbook. The student handbook stipulates the do's and the don'ts within the four corners of that university or institution of learning. So, you know, the law says where one person's right stops, that begins another person's freedom. Put it the other way around. Where my duty starts, here begins your right of freedom. So the institution of learning has duties. They also have rights. The students have duties. The students also have some rights. Now, don't forget that when a student surrenders, it's just like what we call submitting to the jurisdiction of a court. When a student submits himself under an institution of learning, he volunteers to abide by the dictates, the do's and the don'ts of that institution of learning. For example, it is not compulsory for somebody not to study. But when you are within the four corners of the university, you cannot say that you have your right to freedom of liberty, that nobody should compel you to study. Don't forget, the student's handbook has made it compulsory that students must be attentive, must be regular in class, punctual in school, and make sure that they carry out every activity within the period they will be in that school. This is where the law comes in. Okay, before we go into where the law comes in, taking into cognizance some of the decided cases as regards to students, university, debacle in the past and even in the present, let us examine some of the statutory provisions as regards to the disciplining of students. We'll go first and examine section 17, subsection 1 of Olabisi Onabanjo University law. Section 17 sub 1 says, subject to a right of appeal from the decision of the Senate to the Council, the Senate shall have power to deprive any person of any degree, diploma, certificate, fellowship, scholarship, studentship, bursary, medal, prize, or other academic title, distinction or award whatsoever conferred upon or granted to him by the university, if after such inquiry as the Senate may deem necessary, the Senate is satisfied that he has been guilty of scandalous or other dishonorable conduct in obtaining the same. Now, don't get it wrong. Remember, there is mention of the word studentship. This ordinarily would have applied to somebody who has concluded his studentship period in the institution. But don't forget, there is studentship. So as at the time you are getting admission into that institution of learning, that is conferment on you. They are conferring on you studentship. So while you will be being a student, you can still be subjected to certain disciplinary measures. Let us also read out subsection 2. Where the Senate is satisfied that on academic ground, it is necessary to do so, the Senate may, as the circumstances may require, withdraw or direct the withdrawal of any fellowship, scholarship, studentship, bursary, or other academic award whatsoever granted to any student or other person by the university. Now, when we look at the first 17 subsection 1, we'll see that basically it covers mostly those who have earned. They either award, degree, or whatsoever. But subsection 2 now gives us student or other person by the university. So, as a student, if by any reason whatsoever, you can see how powerful that is. If by any reason whatsoever, the Senate decides that you are not fit and proper by their own standard, the studentship can be withdrawn, or you can even be advised to withdraw. We can see the last item in this list, suit number M12-2020. It was a case handled by myself against Olabisi Onabanjo University in favor of a pharmacy student. We'll come to it. Now, the student was, the case is between Akisoya Kayode Akisoya versus Olabisi Onabanjo University. I instituted the case. We lost the case technically on technical grounds, and I was of the opinion to proceed on an appeal. But I just looked at it that this is a student, and proceeding on appeal, we deprive this student a lot of things. And this is Nigeria. Most of the appeals that I filed since 2018, they are yet to be listed. These considerations, when put on the table, I told myself and I told my client that, look, let us devise other means to have these things settled. You can see, I'm trying to point out, first, I've mentioned the non-justiciability of the right to education, which the Nigerian government has illegally deprived the Nigerian child. Right? The Nigerian system has technically deprived the Nigerian child of the opportunity of free, compulsory, and primary education. What did the courts do in the case of Anthony Okoje versus Lagos State Attorney General and Section 6, subsection 6, paragraph C? What did they do? The court said they cannot adjudicate on matters that has to do with fundamental principles and directive principles of the state policies. Now, I've also mentioned my case involving my client. So I am trying to also show you how the Nigerian judiciary, the Nigerian legal system, has also contributed in watering down the rights of Nigerian students. Now, let's examine also Section 31, subsection 2 of the Olabisi Onabanjo University law. It says discipline of students. Subject to the provision of this section, where it appears to the Vice Chancellor that any student of the university has been guilty of misbehavior, the Vice Chancellor may, without prejudice to the exercise of any other disciplinary powers conferred on him by this law, the statutes, ordinances, or regulation, direct, 1, that the students shall not, during such period as may be specified in direction, participate in such activities of the university or make use of such facilities of the university as may be specified. That's rusticating a student. 2, that the activities of the student shall, during such period as may be specified in the direction, be restricted in such manner as may be specified. C, that the student be rusticated for such period as may be specified in the direction. D, that the student be expelled from the university. Now, it's all about the disciplinary measures. Well, the question is this: what happens when the institution, or are we saying that they are all paragon of virtues? They don't make mistakes. What happens to the student when the university makes mistake? I give an example, the case I was talking about. My client applied for leave of absence because he had lost his mother, he was going through depression and some other critical things that was going on in his life at that time. He applied for leave of absence through the dean of his faculty of pharmacy. Yeah, I think faculty of health science or so. But I mean, he was studying pharmacy then. The leave was approved. He was granted the leave of absence for 2 years because of what he was going through. Could you believe that while he was enjoying his leave, scores and marks were being recorded for him? Exams were being noted on his behalf, and scores were recorded on his behalf. Of course, you will know what score somebody who didn't participate in an exam will gain. So when they put and computed all the scores that he had during the stay, he was now advised to withdraw. By the time we contested, he appealed. Look, you approved my leave of absence, and you were also at the same time recording marks for me when I was never participating in exams. I didn't pay school fees. I did not participate in exams. So how come about these things? Well, you know the Nigerian system and the civil servants moving from one table to the other, one table to the other. Before you know it's, I mean, the young man has put in a year, and we started writing appeals from one appeal to the other, from one appeal to the other, and he got to a point. I said, "Look, I can no longer proceed. I have to take this people to court." Now, you asked him to withdraw, but did you grant him what the law has established in Section 36, which was clearly established in the case of Garuba versus University of Maiduguri? It says when you want to, be it rusticating student, expelling student, asking this, advising the student to withdraw, there has to be fair hearing. Section 36 of the 1999 Constitution. Every student must be given the right of fair hearing. It is a constitutional right, fundamental right of every citizen who is also a student. So the case of Garuba versus University of Maiduguri, in that case, Garuba was charged for misconduct and was expelled. He wrote to the Senate of the school to reconsider his expulsion. After a series of writings, the Senate reinstated the expulsion. He proceeded and went to court. The court of first instance did not give him audience. They said they cannot look into the affairs of universities, that every university has power and right and control over their students, and they can do with them the way and manner they want. He moved on to the Court of Appeal. Similar thing repeated. And then he was forced to go to the Supreme Court. In 1986, the Supreme Court, a full court, said, no, why did you grant this young man fair hearing? Are you telling me that the VC can just wake up one morning and say, look, I don't like your face, therefore you can no longer be a student in this school? So if that happens, then we are at the mercy of the vice chancellors, not at the mercy of our performance in the school. It's a contract. There are rights, there are duties. You cannot just wake up one morning and say, this student is hereby rusticated or hereby. There must be what we call fair hearing. So if you don't grant the student the fair hearing, then, I mean, there is absolutely something fishy which must be looked into. Now, in the second case there, that is the case of University of Ilorin versus Akinola. At the court of first instance, similar thing that happened at Garuba. Second instance, Court of Appeal, similar thing happened. Let me even read out what the Court of Appeal said there. The Court of Appeal said in University of Ilorin versus Akinola in 2008, decision of the Court of Appeal says, courts cannot and will not usurp the functions of the Senate, the council, and the visitor of the university on the selection of their fit and proper candidates for passing and for the awards of certificates, degrees, and diplomas. If, however, in the process of performing the function under the law, the civil rights and obligations of any of the students or candidates are breached, denied, or abridged, it will grant remedies and reliefs for the protection of those rights and obligations. They went further. The University of Ilorin appealed. The University of Ilorin proceeded on appeal. And the court said at the Supreme Court, repeating similarly, but in a different word, what the Court of Appeal said. The court said, the court will not readily and cannot in any disguise usurp what is appropriately the function and powers of the Senate, the council, and the visitor of the university in the selection of their proper candidate for awards of degrees, diplomas, and certificates. So when you look at the entire thing, you discover that it was very, very important that I gave a background of Section 17, 1 and 2 of the Olabisi Onabanjo University, as well as Section 31, subsection 2, which talks about the powers of the Senate, the Council, and the Vice Chancellor. Now, if we recall in Section 17, the law says, an appeal shall lie to the council from the Senate. So it's like a court system. When the proper fair hearing has been, mark that word, fair hearing as entrenched in Section 36 of the 1999 Constitution, which says everybody must be given what we call the right to be heard. The law says hear both sides. Right? So there is, am I still here? Yes. Okay. There are two ways to it. The first is what we call ad alteram partem, which says hear both sides. The other angle to it is nemo judes in consensuem. You cannot be a judge in your own case. So this has been the battle going on between the universities and the students. Because in the first place, it is the university that wants to rusticate this person. It is the university that wants to find this person. It is the university that wants to discipline this person. It is still the university that will constitute the committee. So there is no way one of the legs of Section 36 of the 1999 Constitution as regards to the right to fair hearing will not be breached. Do you now see where the students will always have a day in court? Now let's see what happened in the case of Ado Egerebu Emmanuel versus Covenant University. It's a case that happened recently. I participated in that case. The lawyer that represented the student was Femi Falana. I was partly working with Covenant University in that case, but I just gave an opinion, not necessarily that I was at the forefront of the case. But I was present on the day the case was decided. It was decided by Justice Majiko Dumi. Now, this is what happened in that case. This young man, it was alleged that he was involved, is it pornography or whatever? Of course, you know Covenant University. The penalty there was expulsion. He was involved, was it cultism or I can't remember again. It's been long, but I know I took part in this case. But it's either of these misconducts. Let me get the law report. So the student, acclaimed by the university, was involved in, yes, distribution of erotic material. He said he sent through WhatsApp his male organ to a student, you know, and then from there through WhatsApp, a screenshot of his male organ and romantic whatever to another student. So I'm mixing it up. There were actually two cases, but this one talks about the issue of pornography and somebody snapping his male organ and sending it to a female student. And then from there, the team went out. The university just came out, you know, and, you know, expelled the student. Without hearing from him, did this thing happen? Were you the person that sent this, that? You did not even carry out proper investigation, you know. And then when we were called, after the student had taken them to court, we were called. I said, look, in my opinion, when I was, you know, co-opted into the matter, I said, look, there is no way this young man will not have his day in court. You shouldn't have expelled him. You see, universities are always eager to expel students, but they don't know that such actions are detrimental to them long run. Because if you had taken time, constituted an independent body that will summon this student, let us hear you, sir. It's all over the school that you circulated your male organ through a WhatsApp platform. How come? You know this is against the students' handbook and students' duties and the rest of it. How come you are found in this kind of mess? Just tell us. It is for him to defend. It is for him not to defend. But let him be given that opportunity of alterum patem. That is hearing both sides. Even the heaven, during the creation of the world, God, who is the ultimate, had cause to hear from Adam when Adam went beyond his own boundary. So universities are usually making this mistake, expelling the students before considering whether they've been able to do the right things or not. Right. So if you look at it from this perspective, you will discover that there appears to be some level of rights available to a student. What are those rights? Basically, is the right of fair hearing at every point in time. Unfortunately, the right to freedom of education has been eroded deliberately by the 1999 Constitution and aided by, permit me use that word, non-active or activist jurists. Because let me tell you, as a judge, for me, if I were to be a judge, and you bring before me cases that borders on the responsibility of the government to provide, tell me why you're not providing it. So I will interpret this law upside down. Okay, look at what happened recently, where out of trying to make sure that there is equality, the word "and" found an exit route from our constitution. Let me not be political, but let me concentrate on the subject of our discussion. So sometimes there is what we call judicial activism. You have to wake up to the reality. How can you say that when the government fails to provide these things, there is no court that can entertain any claim against any government on account of their inability to do what the Constitution has said they should do? I mean, where are we? So that has also eroded some of these rights. Now, do you have right to buy handouts? Do you have right to object to imposition of handouts, textbooks, and some other instruments you need as students in the course of your training? Now, it's yes and it's no. You see, everything depends on the approach. When you look at the student's handbook, it's very exhaustive as regards to this. But these days, even students are culprits themselves. They find it difficult to report lecturers who are imposing handouts, textbooks on them when the handbook has clearly objected to the sale of handouts and textbooks to students. But there are instances where the handbooks in some of these schools, universities, spell it clearly that students must get their handouts. Now, another area is, does the student have the right to live outside the university? These are very critical areas that people don't even look at. When you're a student, your handbook spells it out, the modalities of operation. Are you to be in campus? Are you to be off campus? Most people that apply for schools, you will hear them making some options available in campus, off campus, online, offline, and some other of these things. These are some of the inventions which COVID-19 has now brought on the table. When you talk about on campus, a student is expected to be on campus for a number of reasons. One, full participation in academic activities. Two, safety and protection. Three, to enjoy all other privileges and entitlements. For example, access to the library, access to the laboratories, access to all other facilities of the institution that will aid his stay and learning in that institution. But today, you hear students having cause to live off campus, but they are in school. You begin to ask, how come the government is not living to its responsibilities? Students are expected to be provided accommodations. Look, if you know you don't have the facilities to accommodate that number of students that you can accommodate in terms of shelter and in terms of classroom and in terms of equipment for academic training, you don't have any reason whatsoever to confer studentship on such candidates. You reject them You cannot bring them in, keep making them, collecting thousands of naira under the pretense of school fees and what have you, and yet the facilities to learn, you cannot provide them. So students are being shortchanged in this regard. Now, is there possibility of a student approaching a court to enforce his right to be provided accommodation in the school? The answer is yes. By the time you go through the handbook of the school and the enabling law, because every university, especially government tertiary institutions, there must always be a law establishing it. The law must make provisions for both academic staff, non-academic staff, students. There is always provision for accommodation. But today, do we see such things? The answer is no. So that takes us to the concluding part of our discussion. Students' rights merely a myth or a reality. So by the time we take time to examine all that I have said, I don't think it will make a very good argument if the otherwise will be the case, because your right to be educated in the first place has been thrown into the dustbin by the Constitution itself. You begin to wonder, what kind of country are we? So, as a way of international best practice, students have rights. But domestically in our country, it's a myth. But don't say I told you. So I really appreciate your time. The time you have put together to be with us in the course of this discussion. I wouldn't know if it is time to entertain questions.
Thank you very much, sir. We really appreciate your knowledge. What you have impacted in us is, in fact, is not little. In fact, it's highly priceless. I'm hearing some for the first time now, which I believe some other participants to be hearing those things for the first time. Which I believe some other participants are just hearing this for the first time. However, there are a lot of points in what you have said so far. In fact, so you cannot be a judge in your own case, which is a thing that is, in fact, has turned to a phenomenon that is happening in our tertiary institutions. Many students will just be rusticated for just other fair punishable offenses where you cannot challenge an authority, anything goes. In fact, let me leave the floor for the participant to ask their questions, because I already have my questions here, but let me give the participant the opportunity to ask their questions first. If you have any question, please kindly signify by raising your hand or send the question to the chat section. So my first question is this, while we wait for others to send in their questions. In the case whereby there is a clash between fundamental human rights and school law, which one is supposed to overrule? Which one is supposed to hold? For instance, I have the right to my own religion, and my religion can say I should dress in a way, in a particular way, which is in conformity with my religion. And the school now says, no, you cannot dress in such way. Which one should overrule or which one should stand? Is it the right that I have the right to practice my religion? My religion has a particular dress in which that dress is still modest, because we believe school want to uphold modesty, that our students should dress modestly. And this dressing is still modest enough when it comes to modesty, but the school says no, you cannot dress in such manner. An example out of case that is happening from schools now, like FUNAB. There's issue of niqab, long hijab, some schools too. Hijab and Co. like that. Hijab and Co. So which I think that one has turned to a national issue. That is one. My second question is this. I have some students, which are even my uncle, my cousins, nephew, and co. They attended a school, Olabisi Onabanjo University, the engineering section, which happens to be at, where is it called? Ifo area, Ibogun also. So for about 4 years now, they have not been, in fact, they cannot graduate. And why? They said the school misplaced their results while moving during in transit and co. So those guys are just there. Nothing is happening. The SUG has already come into the case, and yet nothing is happening. So it's just like as if the years, 4 to 5 years spent in the school is like a waste. This is not new to many people. OU, it is happening there. And in fact, a government institution for that matter. So nothing is happening. Can there be a way that the student can go through that will make the management of the school to provide their results? They sat for the exam, they wrote the attendance as they sat for the exam. For them to now see the results, no results can be presented to them, therefore, no graduation. The engineering student, especially the civil engineering and I think electrical electronics. That is question number 2 for now. You can respond to those questions while we wait for others to ask that question, sir.
Okay, a very good question. That is very contemporary. In the first place, what we are talking about is something that has already been covered and guaranteed by the Constitution. I will read section 38, subsection 2 of the 1999 Constitution. It says, no person attending any place of education shall be required to receive religious instruction or take part or attend any religious ceremony or observance if such instruction, ceremony, or observance relates to a religion other than his own or a religion not approved by his parents or guided. You will recall that in the course of my discussion, I said it is important for us to understand who is a child, the age bracket. There are people that they enter the institutions as children, as people that fall under the age bracket of a child. At that point in time, people that are below 18 years, so said, those people at that point in time, they have their parents, their guidance to make decisions for them. Now, when in the course of their studentship, they cross beyond 18 years, parents or guardians can no longer make decisions for them. Now, you have approached an institution of learning, a religious institution. I like what is going on now. A lot of religious organizations are participating in school and academic activities. Perfect. Now, if a child gets involved in a school, especially public school, a school where, as at the time he was entering into the admission or getting the admission, the terms and do's, the don'ts and applicable principles have been made bare to the parents, and they consented. I give you an example. If I'm a Christian and I decide to take my child to Peace Foundation, which is purely an Islamic institution of learning at Quarry Road, and then when it was time for Jumat, my child is expected compulsorily to join in the activities of that school. This is a private institution. Now, the right rises differently when it is a government-owned institution. When I mean government-owned institution, I mean public institution. In a public institution, because Nigeria is a secular state, if you can remember under section 12, where the law says there is no religion that is superior above any other. Section 12 of the 1999 Constitution. Let's see what it says. No, section 10, sorry. The government of the federation of a state shall not adopt any religion as a state religion. Section 10 of the 1999 Constitution. So it makes Nigeria a secular state. So any public institution, a child is not allowed to practice any religion that his parents, guardian, has not consented to. But where it is a private institution, which is clearly established under certain norms, for example, Crescent University. Yeah, sometimes the school, the Crescent University, maybe as a result of the understanding of Baba and the people managing the school, you can't dispute it. It's an Islamic institution of learning. You cannot go there and they are carrying out or observing Jumat and you say you cannot participate. It's not allowed. But in Crescent, today, even Christians, whether they are participating in the Jumat or not, nobody is disturbing them. Can that happen in seminary school? No Muslim can participate in a seminary school where the priests want to go for their evening prayer and the Muslim says he wants to use his mat to go and pray. You are not going to stay there the next day. You'll be expelled. So you see where the line has to be drawn. Is it a public institution or is it a private institution? If it is a public institution, then on no account shall any child, as the Constitution has stated here, in section 38, subsection 32, subsection 2, that no person attending any place of education shall be required to receive religious instruction or to take part in or attend any religious ceremony or observance if such instruction, ceremony, or observance relates to a religion other than his own or religion not approved by his parent or guardian. So at the point you are getting admission, you have to understand what is the mission, vision, principle, founding missions of the institution. You cannot go to a school where a reverend father is the proprietor and expect not to be called out for prayer during prayer. So these things are better understood. But where it involves a public institution, the case is different. You will not force that child to participate in such observance, ceremony, or instruction. The second question you asked regarding students who have completed but they cannot be allowed to graduate. Let me tell you, so many things and shenanigans are going on in institutions of learning, especially public institutions. Unfortunately, like I told you about this case, I became handicapped because I knew by the time I go to the Court of Appeal, that student will be reinstated. sometimes, permit me say it, because the institution is a government institution. The high courts you have approached is the judiciary of that state. Permit me. Judges are manned by human beings, not by robots. They are human beings. So many things come into play. They consider a lot of factors. So by the time the judge is not willing to, the Court of Appeal is there. Who probably that may have been elevated to Court of Appeal from maybe one of the eastern states, that he doesn't even know who is the governor of the state, who is even the vice chancellor of the university. He looks at it. I believe that what this judge has done is improper. You see, regarding Onabiso Onabanjo, you cannot just go to court. When I went to court on this case, it's what we call, being a public institution. A civil servant, the duties, the functions, and the compositions of its office is regulated by law. Now, when a public servant fails to do what he's supposed to do, there is a remedy. That's what we call judicial review, certiorari. You now approach the court for what we call judicial review. You first seek the leave of the court by an expert application. Then, after the leave has been granted, you now approach the court formally. A lot of people make the mistake of quickly rushing to court. No, you need to exercise this procedure. This procedure must be adopted. You seek the leave, because that's what the law has said. You must seek the leave. You'll be granted the leave, because you are trying to do what we call judicial review. Judicial review of an administrative activity, administrative function. The vice chancellor, the people in charge of the institution, have the duty to make sure that these students graduate so time. But they have failed in this duty. The vice chancellor, you cannot move to his office and say, allow this boy to graduate. No, you do that by what we call judicial review. So by the time you approach the court for a judicial review of an administrative duty or function, the court will now compel him to do that. Or if they have carried the duty wrongly, you can also come in and test it by what we call judicial review, in which case you'll be asking for certiorari to quash what they have done. For example, the one I told you, the case I told you, involving the students, pharmacy student, I went to court, I obtained the leave, the court granted leave, I came before the court, I said, look, they have asked this boy to withdraw. That is an administrative decision. I cannot be asking you to mandate them to take the decision, because already they have taken the decision by asking him to withdraw. No, I'm now asking the court to come by way of certiorari and quash that decision they have taken. That's judicial review. So, students who have graduated, but the school decided to be doing whatever they want to do, the students can now go to court and mandate them to search the archive of the school. Look, you are custodian of these things. I wrote this exam, and you are telling me cocktail shit. I cannot take this. Go to your archive, find out what you have done with my record, graduate me. I came here, your handbook says I should stay for a period of 4 years or 5 years, as the case may be, for this particular program. So how come I'm staying here 6 years and I have no carryover? I have no, what do you call it? All these things that happen among school students. that will make them not to, I was never rusticated. I never absented myself from school. It is now time for me to graduate, and you're telling me another story. No, it doesn't work. They are messing up a lot of youths. They are messing up a lot of future. So you see why it is important for the courts to wake up and help in the enforcement of the right of students, of the Nigerian students.
Thank you very much, sir. We have Mr. Lukman raising his hand here. Mr. Lukman, you have the floor, sir.
Okay, yes, thank you very much for giving us this awesome lecture. My question will come in 3 or 4 folds, and I want to summarize them in brief. 1, looking at the popular University of Lagos, I know in the past we've had cases of students versus university, or let me say student versus management, in which the management will rusticate students after setting up a panel within the school, and at times will not be willing to go to courts, even when the students want to go to courts. I know we've had cases of student union in different institutions in Nigeria, student unions versus the school management, where the student union will prescribe for one reason or the other, and the union leaders are also rusticated. I wouldn't know if, in most cases, the union leaders are rusticated after a panel is being set up by the school, meaning the management is still the judge in that case. Can the rusticated students go to courts? Then thirdly, there is one common incident in many of our tertiary institutions where students at the point of graduation will be having some courses as missing scripts, while what we understand based on some arrangements in the academic session or in the academic system, there is not supposed to be anything like missing scripts. If 100 students start for an exam, wrote an attendance of 100, and 100 scripts were put in the same folder for a lecturer to mark, why would the lecturer come out with 98 scripts, and eventually the students will be had to bear the brunt of missing scripts, which might eventually lead to an extra year. An extra year will cost the student more time, will cost the student more money, will cause the student more trauma and more stress. What will you advise the students in this third case to do? So there are 3 different scenarios I've just built up. How can you advise we address it, and we address it for many of our public institutions? Thank you very much.
Thank you for your question. UNILAG is my alma mater, where you have Professor Shikweto and the rest of them. Talking about the issue of UNILAG setting up the panel. You see, yes, the management sets up the panel, but the thing you're having as a dispute or conflict may have emanated from a section of the school, either from the departmental level, from the faculty level, students' union, government, students' affairs. So at that point in time, the panel that is set up, what is the basis of being set up, and where did they draw the membership from? For example, if you are in the Faculty of Medicine and the disputation in question is within the Faculty of Medicine, it's not expected that the panel should be drawn from the College of Medicine. Even MedLab, it shouldn't come from there. The panel is expected to come from either theater arts, law, engineering. The essence is to give people that have unbiased mind People that will give you the opportunity of saying something without condemning you. People that will give you the opportunity of what to call benefit of the doubt. People that will listen to you without having premeditated decision. Or people that have already preempted what should be the outcome. More or less a teleguided platform where you are just coming, you know, just say, you will say, like they will say, the minority will have their say and the majority will have their way. So if you look at it, the panel was drawn from the faculty where the conflict emanated from. You don't expect them to do the right thing. So at that point in time, you can question the integrity of whatever decision that will come out of it. Because, look, that is why fair hearing has two pillars. The pillar of hear both sides, and the pillar of you cannot be a judge in your own case. So if the panel, membership of the panel is drawn from Faculty of Medicine, then be rest assured that you are sitting over your own case. So once you can be able to establish before the court that there is likelihood of bias, not even that there is a bias, once there is, you can establish that there is likelihood of bias, this professor is the colleague or member of social faculty with this person whom you are having grievances with or disputation with or conflict with. I mean, that's enough for the court. So that's where we call you cannot be a judge in your own case. So that's for that. And then issue of missing script. Look, it's important for every student to acquaint or be abreast with the student's handbook. You cannot change the rules in the middle of the game. No, it's not. The rules must specify the do's and the don'ts. If there is nothing like missing script in the handbook, why do you have to attribute it to me? There will always be a way. It's an eternal administrative problem that should be solved administratively. Either you call the student, rewrite the script. Immediately, the student must be given the opportunity to rewrite the exam. Not that you tell him, go. Go where? You should go to his father's house and manufacture script and write. Give him an exam. You are the lecturer. You are the lecturer. You are the supervisor. Give him the exam, another exam. It's a different thing. You wish to give him exams, questions, different from the earlier one, but give him an exam. So this idea of making students repeat a full 1 year simply because of a nonsense not caused by them, it's very, very unfair. And it's very, very unjust. And if you go to court, because, you know, it's not something you quickly rush to court. You must have exhausted the internal remedies. For example, the lecturer who is saying that you have a missing script, that lecturer has a dean or sub-dean to complain. When the sub-dean is unable to act, you have the dean. When the dean is unable to act, you have the vice chancellor. When the vice chancellor is unable to act, or before the vice chancellor, you go to the dean, deputy vice chancellor, academics. When he's unable to act, you go to the vice chancellor. If the vice chancellor is unable to act, you go to the Senate. If the Senate fails, the council is there. you must exhaust these internal remedies. If you rush to court, the court will not give you audience. Why? Because you are still their student. But if you have been rusticated, expelled, withdrawn, at that time, as Section 31 sub 2 have said, you are no longer entitled to the benefits, rights accorded to students. So you are no more students, so-called. At that point, you can go to court because the internal remedies that we are talking about are not meant for you. They are meant for students, and you have been expelled. So the status quo at that time is that you are an expelled student. So it is only the court that can attend to your grievances. But if you are still a student and the case in question is a case of missing script, you must exhaust the internal remedies, which I have highlighted the hierarchies. So that is the case of the missing script. I understand the challenge. The challenge could be before the subdean will act, it may have taken 2 months. Before the file will go to the dean, it may have taken 4 months. That is the Nigerian system we have found ourselves. So that is for this. Am I missing out any other question?
I think no, sir. Thank you very much, sir. There is still one more question here. And the question is this, sir. Some private institutions, they will be training students on professional courses in which they themselves have not gotten professional accreditation. And by the time these students graduate, for them not to sit for the professional exam, it will not be an issue. So these students will now be like straight students now. Nowhere to go, can't go back, can't go forth. What is your advice for such school and students? Courses like law, like medical lab and co.
You see, there are things that happen in this country. I will attend to this question, but let me address an issue that is becoming the order of the day. Students are usually desperate. It is in this part of our world that a student will see what is wrong and still go ahead to do it. Every student is expected to know whether an institution of learning has an accreditation. This thing is so much, especially as regards to law and medicine. A school, accreditation is not what is hidden. It is something that is, because it is a public institution that accredits both private and public schools. It is public institution that accredits them. National University Commission accredits all schools. If it is a professional program like law, the Council of Legal Education accredits universities that offer law. Council of Legal Education is a public institution. Students are expected to do certain things themselves. For example, you see, as a student, some of the things you'll be engaged in the course of your learning is research. If ordinarily to find out if the school you are moving into affiliate yourself with, whether they are duly accredited or what they are saying they possess it or not. If a student cannot take, it upon himself to find out if truly what I'm saying, this school says they have, whether they have it, then there is a problem. Every student is expected to know what is obtainable. So that's my response as regards to that. I want to address it. Now, what will be the issue? If the school had, put out to the public that they are accredited, there is a fraud there. So you are giving me what you do not have. You have obtained my money under false pretense. Section 419 of the Criminal Code Act. As at the time you are making me to part with my money, part with my time, part with my resources, you didn't have this, but you made me to believe, and I acted on that mistaken belief that you have this, then you are liable for my time, for my expenses, and you will pay dearly. Students are expected to go to court and claim damages, especially if that school, and you can be able to show that the school portrayed itself as an institution that has the accreditation. But where you cannot be able to, and the school comes forward to say what we call contributory negligence, whereby you contributed to your foe, you contributed to your problem, the court will say, oops, to your thankful Israel. Why? Because you saw the gutter, just like what I addressed earlier. You saw the gutter, you could have jumped across, but you feel to enter it. So you have nobody to blame. But where you will have your day in court is where you can be able to establish that the school, puts itself out as having such an accreditation when it does not.
Thank you very much, sir. The last but not the least is, you made mention in your speech that an institution can withdraw an award given to an individual. Does it mean that the BSc certificate, ND certificate, HND, MSc, PhD that I've gotten from an institution can be withdrawn from me due to some reasons, or what, sir?
I will refer to a case that happened recently. The case of Audrey Zocalo versus APSU. They are in the Supreme Court now. APSU in 2012, 2013, called up Dr. Audrey Zocalo. Let me withdraw that word, doctor, because that doctor has been withdrawn. And they said, you obtained this qualification by fraud. We hereby withdraw it. He went to the High Court. The court confirmed it. That yes, they are the people with the power to award. He who has the power to give also has the power to withdraw. They awarded this thing because they felt you are fit and proper. But now they have discovered that you obtained it by fraud. Therefore, they have the right and the power to withdraw the award. I can make the case available. It's here. I published an article recently. It's contained in that case.
You said by fraud. That fraud now doesn't mean that he used the fake result or what?
Now, you see, when we were in school, I don't know whether they do it now. Even currently, in my doctorate program, we are expected to meet certain requirements. If you are required to go for internship, for example, and you went somewhere, colluded with the organization, and the organization issued out a letter. And later, it was discovered that that organization was actually your business, or that organization was fraudulent in issuing that letter that says or certifies that you have gone through the training, internship training. And don't forget, except where that internship is not made a prerequisite to the graduation or the award of that degree, if it is made a condition that once it is established that that internship you did not participate in it, that award must be withdrawn. So in Orji Zokalo, they went to the Court of Appeal, and the Court of Appeal says, yes, the lower court was right. The university, ABSU, Abia State University, it's a part of their disciplinary measures, and the law establishing Abia State University, stated like the one we have read now in section 31, sub 2 of the Olabisi Onabanjo University. You can see that the Vice Chancellor can come out. Although it is apparent that that of Orji Zokalo was politically motivated, but that's a discussion for another time. So they were able to establish that, okay, like I was saying earlier, in my university, we used to sign attendance. If a student didn't make up their attendance and the course rep, for reasons best known to him, awarded him attendance, whereas he did not participate. What are you saying? Except the attendance is not one of the conditions for graduation or for passing each level of your training. You understand? So, you know, people take a lot of things for granted. But this is very crucial and very fundamental. You know, so that is for that. A school that has power to award you a degree also has the power to withdraw it. I'll get that case now. I will make it available now.
God bless you so very much, sir. I really appreciate your tutelage. We appreciate this enlightenment. Those are yet to be known by many Nigerians. Really appreciate it. Dr. Olubode Timothy, can you give the vote of thanks?
Oh, thank you. Good evening, sir. Thank you so much, sir, for this wonderful lecture. It is an eye-opener to each and to every one of us that have participated today. I don't know why some people are just left. But all the same, it's a wonderful lecture, and I really appreciate you for that, sir. I believe in the next class, the next lecture, I wish people will be able to attend because, and then those cases you also explain. Well, from my own side, I will maybe by next lecture I should be able to ask some few questions relating to some legal issue relating to this right of 18. But for now, it's just how do I put it? It is awesome hearing this, and I believe this will enlighten more people. So we also appeal that you help us with the slide to give us more cases in the slide that you'll be giving to us concerning this one. Thank you so much. Thanks to every one of us that have participated, and I encourage us to take time to set time and schedule ourselves for the next lecture. And God Almighty will help each and every one of us in the mighty name of God.
Thank you, Dr. Olubode. Once again, we appreciate Barrister CJP Ogbara. But we cannot thank you enough. I personally have learned a lot, despite my graga that I think I know some things. In fact, I know nothing. I know nothing. I never knew school can withdraw my certificate. I never knew that at all. I never knew. You know the post. You do not have enemy that will track us down. Really appreciate you, sir. So we'll be glad to have you this again. Let's move to the session. The second Wednesday and the third Wednesday. Then we'll be having employee and employers' rights. So I think that many people will also gain a lot from, because many staff don't even know their rights. Many employers don't know their rights over their employee. Or likewise, employees don't know who is our right when it comes to rights at work. So I think we have more participants than this in the next class that goes. This awareness is very short. We're supposed to have fire service webinars today. But unfortunately, due to some Nigerian factors, we're unable to turn up on time. That's why I just said we should bring this now. This is supposed to come next month. We really appreciate it. Despite the short notice, we are still able to meet up with our demand. We really appreciate it, and God will bless you more. God will bless you more and more in all ramifications. So by God's will, before the next webinar, our team will visit you, come and discuss some issues with you as well. So we really appreciate it, sir. Thank you and God bless. See you all next session. Bye-bye.
Thank you so much, sir. Thank you.
So you end it. So let me share.